This is an informational hearing on workers' rights and religious employees after the Hosanna Tabor decision was issued. I appreciate everyone for coming here. This is an important issue that really looks at the constitutional protections of the church against actions by the government, but also in California has long had a strong history of protecting employee rights, and the Hosanna decision affects really both of those. This is a hearing to explore the topic.
This hearing and this issue came about many, many months ago, obviously, when the Archdiocese here in San Francisco decided to try to insert a morality clause into the contracts of the teachers and the staff for 4 high schools. And those 4 high schools are very, very precious to the entire Bay Area. They're extremely prestigious. They have a history of really graduating many of our leadership within the city, but also throughout the area and throughout the state. And we really thought that it was important to try to understand how do we balance, again, an institution's ability to have religious freedom, which is sacrosanct in our Constitution, while at the same time, how do we balance people's civil rights and employment rights at the, who are employees, and to ensure all the employment protections that we have in the United States, all the employment protections we have here in California are really ultimately protected.
The context in which the ministerial exception arises is in the midst of a lawsuit. It's what lawyers technically call an affirmative defense. And so an employee of a religious organization goes to court, and at that point the employer says, no, you're a minister. And if that person is a minister, it's a silver bullet, that it's an affirmative defense that ends the lawsuit.
All of the statutes that we deal with have exemptions. Government employees are exempted from the Fair Employment and Housing Act. Airlines are exempted from the National Labor Relations Act. Agricultural employees are exempted from a lot of laws. So what that means is that the legislature, in most cases, has determined that we're going to enact a law. It's going to say some things are discriminatory, but we are going to specifically exempt people, and we're going to let those people engage in acts that we're not going to let others engage in. So all Hosanna Tabor is a constitutionally required exemption. So if you look at that way, then you're not looking at the employer engaging in unlawful discrimination because there's no law that applies to them. They have just an exception or an exemption.
Whether I'm speaking to elderly Holocaust survivors who teach about their experiences as a persecuted religious minority, or young refugees from the civil wars in Syria and Iraq who have found a community here in California, one refrain I hear uniformly and passionately is how fortunate they are to live in a country that protects their religious freedoms. It means they can be a part of a religious community that embraces their beliefs, that teaches their values, and shares their view of what they believe the world should be, even if it's not always the way the world actually is.
If I have one message for you as a lawyer and as a teacher, it is this. Focusing on the U.S. bishops for the moment, they very much want to characterize what is at stake here as freedom of religion. That is not what is at stake. These Catholic schools have entered the public square. They are not functioning as churches. They are not functioning as religious enclaves or as missionaries. They actively solicit the general public, Catholic and non-Catholic. They want all the benefits of being part of the larger society, economic, political, social, but none of the responsibilities. Freedom of religion is not a broad license to discriminate, and it is not a license to abuse the trust and the well-being of our children. And that, I suggest to you, is what is really at stake here.
All the rights that we have fought for, and they have been victories over years and years and years of efforts, whether they're civil rights laws, whether they're employment laws, that those continue to be there to protect employees.
What worries me is that, and the ministerial exception that I know some of the testimony was concerned about, that's the law, there are good reasons for that. But I think what the concern is that if we start to expand those exceptions to are laws that protect individuals constitutionally from discrimination, that there is a state interest there. There is an alarm that needs to go off. There is a standard that I think California can and should be looking at.